Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about multiple DUIs and what the mandatory minimum penalties are in the state of California, particularly what we see most frequently in San Diego. Okay, so first time DUI, no injury, no problem. 0 days in jail to 6 months in jail. Okay, the likelihood of you getting 6 months is not great. The likelihood of you getting some jail really depends on how bad the blood alcohol level was, what, if any, your criminal history is, DUI, unrelated previously. But in most likelihood, you're going to be dealing with fines, DUI classes, possible. But what I really want to focus this video on is what happens when you get a second time DUI within 10 years. What happens when you get a third time DUI within 10 years? What happens when you get a fourth time DUI within 10 years? Or what happens if you have a prior felony DUI with injury and then you get a misdemeanor DUI down the road? And what we see a lot of times are people who may have, a DUI from 5-6 years ago, they get another one and they don't understand, well, what do you mean? Why do I have to do mandatory jail time? What's this 96 hours jail to a year? Third time within 10 years. What's 120 days to a year? What do you mean I have to do 120 days jail? Fourth time could be a felony charge. Mandatory minimum of 180 days to 3 years. This is no injury here. This is just straight .08 or higher, under the influence of alcohol, one of those two with those number of priors in the past. 180 days to up to 3 years in custody. Okay, and what is important here is a lot of times people hear these mandatory minimums and they sort of throw in the towel and they say, well, what? Okay, well, if it is what it is, right? If I'm 2 times the legal limit, well, I'm probably going to get the mandatory minimum, and why am I going to go spend all this money on a lawyer? When the law says I have to do 120 days to a year anyway. Well, if ever the time actually to invest, even more so in a locally experienced quality criminal defense law firm, it's when you're looking at mandatory minimums. It's when you're looking at jail time, to try and get creative on how you can be proactive to try and avoid jail time altogether. And if you have to do custody time to avoid jail time, and do it in some sort of alternative program, whether it's something like house arrest, which is known as CPAC, it's an acronym, CPAC, attention with SoberLink, okay, where you're monitoring your alcohol intake to make sure you're not drinking under house arrest, where the level up above that will be something like work furlough, where if financial treatment program. And a lot of these things sometimes you could actually do proactively while the case is going on to enable your attorney and the firm that represents you to negotiate a better outcome than if you were more reactive. And that's where a lot of attorneys, particularly in San Diego, make mistakes when representing people charged with multiple DUIs is they wait and they sit on their hands. And they've reviewed the case and they know whether there's a defense there or not. And they wait, and they say, tell the client, let's see what the prosecutor's thinking is. Date, and then we'll talk about what you could do to help your case. And they go in there on a third time DUI, and they're like, okay, hi, I represent, John Thomas, and all right, it's third time years old, and and prosecutor, like I would ask if I was ever a prosecutor, probably won't be, but what I would ask if I was would be, okay, what is he or she doing to address the issue here, right? Because when you have multiple DUIs within a 10-year period, usually that indicates a couple of things. It indicates either 1, you have an alcohol problem, or 2, you just don't care, right? Or you're thumbing your nose at the system, or, admittedly, you might be the unluckiest person in the world who the 2 or 3 times you drive over the legal limit, you actually get arrested and get caught, okay? But from a prosecutor's perspective, they want to hear something that your client is doing or that you are doing as the client, as the defendant, to be proactive in treatment. And a lot of times attorneys will make that mistake, and then they'll go back to their client and say, the offer is 180 days jail, treatment program, or maybe we could put a scram device on, to show them. And then we'll revisit the issue. But already what's happened is the prosecutor's written down offer 180 days jail, no mitigation to show us at this point. And you've already sort of had that preliminary discussion, and then you're working off of 180, or you're working off of 270, you're working off of 240 jail, instead of going there proactively and saying, hey, my client's already enrolled in this treatment program, here's a letter. If we're dealing with the mandatory jail sentence, can we give credit for what they've already done? To maximize the success, to minimize the chance that you actually have to do actual jail time, assuming this is a case that it's worth it to resolve. There are cases where, hey, it's not worth it to resolve it because the facts call for it. You may have a great defense. You may be 100% factually innocent. The offer may be so bad you may not have anything. But it's important when facing multiple DUIs, when you're dealing with mandatory minimum, proactive and not reactive. And the greatest example of how you can be proactive and not reactive is to invest in a quality criminal defense law firm to represent you as soon as possible in the process. Don't make a decision based on cost solely. Don't make a decision based on who has the flashiest website. Don't make a decision on who has the greatest sales techniques in the meeting. Make a decision based on that firm's reputation. Make a decision based on that firm's history. Make a decision on that firm's involvement and their standing in the legal community and the community at whole. Make a decision based on who stands out from the other firms you may be meeting with, even if they might cost more. Because a lot of times there's a reason for that, and the reason is because they provide better service. Not always, but if it's the right firm at the right time, it's because they provide better service, and they may very well be worth it. Do your research, be proactive, try and avoid mandatory minimums, and certainly try and avoid them in jail. If you find or facing, even a misdemeanor DUI after having previously convicted of a felony where you might be facing new felony charges. So if you have any questions about multiple DUIs in San Diego County, reach out to my firm. We can help you regain control of your future, get you on the right path, and walk you through the options on the many different ways this could go. And if we're a good fit for you and you're a good fit for us, hopefully we can work together and help you out. David Shapiro, San Diego criminal attorney, 619-295-3555.